We'll give everybody a little bit of time to channel in, and then we'll get started soon.
Oh, that's fine. I do the same thing when I teach via Zoom.
We're still climbing. All right, well, let's go ahead and get started. Good afternoon, everybody. Thank you so much for joining us for this amazing CLE presentation that we have. Cancel culture at work, social media issues affecting employees and employers. Today we have myself. I will be introducing our panel, and our Tanika Brown is going to be doing the moderating of the panel. Do you want to? Sure.
Hey guys, I'm Tanika.
It's going to be a great dialogue, and hopefully, Frida, if you guys have any questions, we have the Q&A box. Tanika is going to be monitoring that. And from there, I will introduce our lovely panelists. So first, we have Michael P. Maslinka. He is an assistant professor of law.
I'm actually an associate professor. I got promoted.
I forgot we had that discussion. He's been promoted.
Let's just it's a big relief I got promoted. So otherwise, you get tenure. You don't get tenure, you get fired. So I just want to make sure.
We're very excited for him. Over at UNT Dallas College of Law, he practiced law from 1981 until he joined the faculty there in July of 2015, recently promoted. He was the chair of the labor and employment section of a large Dallas firm, and was the managing partner of the Dallas office of two national law firms prior to July 2015. He began his legal career in Houston as a trial attorney for the NLRB. He teaches employment law, employment discrimination law, effective oral communication, professional responsibility, international law, and civil rights. His research interests include litigation, employment law, and professional responsibility. He is a co-author of Learning Employment Law and co-author of Experiencing Employment Discrimination Law. He is the author of a treatise on employment law, Maslinka's Texas Field Guide to Employment Law, FLSA, FMLA, ADA, Texas Labor Code, and the 5th edition will be published, or was published, in January of 2021. He shares multiple articles with Texas Lawyer, a publication that reads across Texas called Work Matters, and seeks to educate the public and lawyers in general about issues affecting the workplace, professionalism, and a number of articles on COVID-19 and its effect on the legal profession and the general public. Additionally, we have Ashley Tremaine. Ashley is the managing partner of Tremaine Artaza PLLC, which is a boutique law firm in Dallas, Texas, that focuses on representing individual employees and entrepreneurs in all manners of employment disputes. The firm is recognized as a Tier 1 firm of employment law and for litigation by U.S. News Best Law Firms. Tremaine Artaza PLLC is a woman-owned business. They take particular pride in the work that they do under the Equal Pay Act, the Pregnancy Discrimination Act, and the FMLA, and in representing female employees working in a male-dominated industry. Ashley is board certified in labor and employment law and is a member of the Texas State Bar College. She has been recognized by the U.S. News Best Lawyers every year since 2013, and she is their 2020 Lawyer of the Year for Employment Law Individuals in the DFW metro area. She has also been recognized by the Texas Super Lawyers for the past 9 years and was one of the top of their up-and-coming 50 women in 2017 and 2018. Ashley is currently a member of the Council of Labor Employment section of the DB Dallas Bar Labor Association. She is also a board member of the Texas Employment Lawyers Association, and she holds down a second full-time job as a mom. From there, I'm going to hand it over to Tanika.
Hey, everybody. Thank you, Adrian, for those wonderful introductions. And also I wanted to start with thanking Professor Maslinka and Ashley for their time today. I just want to remind the invitees in the audience today that if you have a question, be sure to go ahead and drop it in the Q&A box. We're going to do this one in a way in which we can address the questions that come up as well as go over a few topics. So all the engagement is super appreciated and desired, okay? Yeah, so this is going to be more of like a discussion type. I'm going to bring up a couple of topics and such, and I'm really excited because I don't practice this area. So this is something that I'm always interested to know about what'll happen if I post this and how relevant social media is. So I'll just jump right into that. So a topic that we came up with was that cancel culture, of course, the name of this CLE, it seems like a lot of celebrities and actors tend to lose their jobs, or they lose their positions or a movie role or things like that due to their social media posts or the tweets that they tweeted 5 to 10 years ago. Professor and Ashley, we just kind of want to know your take on, is this just a concern for celebrities and actors, or is this a concern for regular employees as well? And if so, have you seen a spike in job and positions and terminations within the past few years, or has this been something that is an overall issue that has affected employers and employees more, I guess, a mass over the past 10 years, or is it a recent spike? Please let me know if my question wasn't clear.
It was. I can speak quickly to, just so everyone knows, I mean, I represent employees exclusively, so I don't represent management or employers, and Mike really has the background on that side of the docket. But on our side, we have always occasionally gotten calls from folks, you know, saying, I posted such and such on Facebook and my employer saw it and they fired me and that's not fair and I have First Amendment right. You know, we've always gotten some straggler cases like that here and there. We never take them because they are not actionable by and large, with few very rare exceptions. I will say I do think there has been a big uptick in it in the past, I'd say 2 years. I can only guess at the reasons, but my suspicions are, you know, one, there's been a lot of big political issues going on in our country in the past couple of years, and people have really taken to social media to express their viewpoint on it. So people are becoming apparently more vocal, kind of more free with expressing their thoughts publicly. And I think there's also more pressure on employers to do something about it. And so between those two things, I do think we have seen a significant uptick in this lately. The viability of the cases, I don't think has really changed significantly. I mean, we send almost everyone with that type of complaint away. I can think of maybe one example of a case that we've actually taken, where an employee was fired because of something that they put on social media. And the reason that case was viable where most others were not was that it was covered by the National Labor Relations Act. So it was a situation where the employees were trying to band together to effectuate some type of change in the workplace. So that's sort of a very narrow exception. But other than that, if it's a private employer, they can fire you. And I mentioned to Tanika at the beginning, I chose to do my presentation today from the playroom in my house to illustrate this point. There's a lot that can be revealed about you on social media, on your Zoom backgrounds, what have you. And if I worked for a private employer, they could easily take a look at this and say, I don't like that artwork, or I don't like that lazy dog in the background. I don't like people who are plant people. Fired. And that's not a case. That's perfectly legal for a private employer. I think there's a lot of misunderstanding out there in the workplace, and people seem to think that they have a First Amendment right to do and say whatever they want and be able to keep their job without consequence. And that's just not the case.
Wow. So I think there have been three main effects of this. And I noticed this when I was leaving practice. And I study this now here at the law school. The first is that employers are increasingly looking at the social media posts, whether it be Facebook or Twitter, in their hiring decisions. And I'll just say that many employers get it wrong, and they make mistakes, critical mistakes in using social media in the hiring process. The second thing I noticed this when I left practice to enter the academy. That's why they call it law school, by the way. They call it the academy. When I left practice, and I still have seen it, and I still study all this, is this it's effective litigation. When I started practice back in 1981, a defense lawyer would never send a litigation hold letter to a plaintiff. Now it's common. The litigation hold letter is, you're suing my client. You know what? They may have social media I'm putting you on notice. Don't destroy anything. We will hold you accountable for it. The third thing, and what Ashley said made me think about it, is that there are many very important First Amendment implications. As you know, the First Amendment doesn't apply to private employers, but it does apply to public employers. And having this sort of outlet, Facebook and Twitter, all this other stuff, is a way for employees to express matters of public concern, who are public employees, and to be protected from retaliation for making that expression, that protected expression. So from a general 30,000 foot perspective, that's sort of how I see the social media affecting our lives as lawyers.
And thank you for touching on that point. The next question that I have for you guys is that how do you feel social media posts have affected the employee-employer relationship over the past 10 to 15 years? And when I say employee to employer relationship, I'm referring to, let's say I'm out for sick leave, but yet I'm really on vacation in Mexico. And I'm friends with a coworker who sends that message to management, or when, on Teams where we are Zoom, for example, where someone, maybe an administrator, could print out the conversations that the employees have, and maybe there's a termination that results in that. Or an example of Snapchat, you have Snapchat and employees, for whatever reason, may take a picture or so drinking on the job, and it gets back to HR, and then there's a termination. I just wanted to see what you guys think that how the relationship between the two has changed over the past few years.
If you don't mind, Ashley, she hasn't thought, I had an immediate thought on this. It's changed and it hasn't changed. Mm-hmm. I recall when I was in practice, I defended an employer in a workers' comp retail case. And the employer, before they got me involved, actually had a private investigator follow around an employee who had been injured. Right? And at the suggestion of the insurance company. I'm changing a few facts, but it's a true story. And so what they had video of this guy, video that was taken of him playing basketball. Supposedly he was injured at work, and he had a bad back, and he was shooting baskets. And so the employer went off the deep end and they fired him. Well, it turns out that after they fired him, during discovery, he had a doctor's note that said, you have a bad back because you need to lose weight. Why don't you get some exercise? Basketball would be fine. And so all the video showed is the guy didn't have much of a hook shot, and he couldn't dunk anything from three-point land. It didn't show he was a fraud. And I see the same thing today with respect to employers. They see something on social media and they go, oh my gosh, they're cheating us. Oh my gosh, look at this. Rather than to find out what really is going on. So it's changed, but it hasn't changed. Employers still, and I've represented employers for many years, don't jump to conclusions. You may see something, but stop and think about the guy with the basketball. Like I said, terrible basketball player. He had a doctor's note. So don't jump to conclusions. What I find sometimes, to toss over to Ashley, is that employers sometimes have it in for employees. Mm. And they're just looking for a way to get rid of a certain employee. Now that I'm in the academy, I can kind of speak more freely.
Yeah, I can't believe you're saying this, Mike.
Well, I'm a tenured professor of law. I can say what I want, basically. I mean, I'm not going to hold me anymore. Anything but my conscience, right? Is they want to get rid of employees, and they see something. They go, oh my God, now we got him. Now we got her. Don't do it. Stop, take a breath, investigate, figure out what's going on. That's so what comes to my mind, my friends.
So can an employer fire you?
Yeah. The thing is,
that's what I always think is so funny about these digs. It's like, you don't even need that. Like, why are you
That's
trying?
right. You don't.
You really don't.
Yeah, that's really right. You can fire them for any reason, but
Yeah.
But I think there's something about employers, they want to have a reason. I think there's something about human nature that says, you know, even I don't like the person, I want to have a reason to fire them. It feels better, right? And so even though you don't have to have a reason, most employers, in my experience, want to have a reason because that's the way human beings are, even employers. Who and not all employers do this kind of stuff, right? People I represented were not always saints, but most of them were. But so no, they don't have to have a reason. But I think it's natural to want to have a reason. And here's the other thing too: even if there's not a discrimination claim, you get fired, you file for unemployment. You want to go to the unemployment folks and say, look, this is why we fired them, not. You know, not I didn't like the way they combed their hair, or they didn't look very good on Facebook. We had a substantial reason. And sometimes what's put on a Twitter account or a Facebook account is that reason and provides a legitimate reason.
I mean, to the question of how has it changed the practice, I think the jury is still out on whether this is really a good or bad thing, but I do think it has really democratized a lot of the process because as Mike mentioned, you know, back in the day, you would have to hire a PI or something to get a lot of this information. And the cost of that, I think, closed the doors to litigation for a lot of folks. Now it's free and it's easy and it's fast to get a lot of the information you need on both sides of the docket. You know, it's not just investigating the employees. I mean, I use Facebook all the time. Every time I get a new case, I'm going on there and researching the bad manager. I'm looking up who GC is. I mean, and it's all just out there. It's kind of shocking what people will openly put on, you know, Twitter, Instagram, Facebook, whatever, you know, platform it is. I think it cuts both ways. I think the line between your work life and your private life is just becoming increasingly non-existent. Mm-hmm. I often wonder if we are going to kind of hit a plateau on this bell curve, and maybe there will start to be some policies to keep some of that in check as more and more people start to realize just how intrusive their employers really can be. I mean, every time I have this consult with a potential new employee client, consistent shock at how little rights they actually have. I mean, everyone comes to my door sure that they have a claim, you know, based on X, Y, and Z, and 95% of the time they don't. And they're like, the employer can't do that. Really? That can't be right. I'm like, yeah, no, they can. They really can. And I think most people don't realize just how little power they have in the workplace, and just how little leverage, how little bargaining power, how little control they really have in that employer-employee relationship. And in a kind of perverse way, I like to see more employers going more and more overboard, because I think that in time, hopefully employees' eyes will start to be open to this issue, because really it's a legislative problem. There's only so much that we can do in the courts. You know, as a plaintiff's lawyer, I'm like, I'm not going to file a frivolous lawsuit. The law does not protect you in this situation. So, you know, sorry. If you disagree that this is a horrible thing to happen, then call your legislators.
Yeah, no, that's it. And that leads me to another question that I have. So we just talked about employers and the relationship that you have. And I do know that, at least I hear about it. I'm not sure if my employer particularly did this, but the pre-screening for interviews where you look at your LinkedIn or your Facebook and things like that, could a potential employee have a claim for discrimination against an employer for looking up information about them via social media before an interview?
I think it depends on what information, right? I mean.
So if I could, it's not that you have a claim about the information. It's that you're considering factors other than the merit of the person. And again,
but I think you're allowed to. It's funny because we're kind of taking the opposite.
Well, no, not really. I'll give you an example. You want someone to get a job or not to get a job based upon, I'll use resumes to make it easy as a job application, because they're qualified for the position. If before you offer them the position, curiosity gets the better of you, and you go and you check out their Facebook page and you see that they're Black or that maybe they're disabled, you then have knowledge of a protected category and classification before the offer is made. That then can lead to what really motivated us. Was it because you saw who I was, or that I was not qualified? What happened? So don't contaminate yourself with knowledge that you don't know. Once you make an offer, you know, often offers are conditional, right? Under the American with Disabilities Act, you can, as long as you have everybody do a medical exam, for instance, then do your due diligence and do your search. But make offers based upon whether you can do the job or not, the interview, the qualifications, the background. Don't go just mucking around out of curiosity. Just don't. I mean, I'm doing an interview later today for somebody at the I'm on the appointments committee. By the way, they don't call it a hiring committee. They call it an appointments committee. Everything's got to be fancy in law school. I didn't check into this. I did not look in LinkedIn. I didn't look at their Facebook page. We'll see. I'll see them, of course, during the interview. But I don't want anything other than their qualities and their qualifications. So employers kind of mess that up, and they just bring problems on themselves.
I think so. From an employee's perspective, I think those are great ideals, and in a perfect world, that's how every employer would approach it. But the reality is they don't. And it's not like there's some law out there that says you can't do it. And so I think the vast majority of employers are going to do it. And so I think as an employee, if you're out looking for a new job, you just need to be aware of that. And I tell every single client that comes to our door, set your social media to private. There is no reason why you need to be out here publicly making all these comments. Like, it's just the risk reward there is not worth it. Shut it down. Don't be friends with people that you work with. Like, it's really fairly simple. If you really can't refrain from making public comments, I tell people to change their name. So maybe it's just your name and your middle initial, or you have like some type of handle that doesn't reveal exactly who you are, and you have sort of your social media persona that isn't clearly tied to your real life persona. There's a lot of things you can do to kind of ride that thin line. But if you've got a Facebook under your exact name, like, be sure that a potential employer is going to look at it, whether you like it or not, and prepare for that. Because from a potential claim standpoint, if someone comes to me with sort of the fact pattern that Mike mentioned, like, I applied for a job, I was highly qualified, I have a feeling that maybe the only reason I didn't get the job is because it's obvious on social media that I'm disabled, or that I'm older, or that I'm Hispanic, or whatever the protected trait is. The problem that a plaintiff's lawyer is going to have with that is one of proof. Good luck getting that proof that the person who hired you, the sole reason that you weren't hired is because of your Facebook, and not because there was some other better qualified candidate, right. Or there were 10.
But it's not the sole reason. Let's say your client, let me finish. It's qualified, and they didn't get the job.
But that's an academic debate. I think in the real world, in a jury, you can argue until your face turns blue about motivating factor versus sole cause. But I think if the employer is able to say, like, here's like 5 other things, this person we hired had a higher degree, they had 10 years more experience, blah, 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 blah. I think as a plaintiff's lawyer, like I'm not taking that case, you know, like even though hypothetically, theoretically, we have a motivating factor standard, at least under the Texas law. I just think those cases are extremely difficult to prove. And as a plaintiff's lawyer working on contingency, I think as an employee, you will have a hard time finding a plaintiff's lawyer to take on that case for you, and an even harder time winning that case. So I think that's the reality that we have to often tell our clients. It's like, yes, even though the law does say this is illegal, what the law says on the books and how it works in practice are two wildly different things.
So you have a client, potential client. They were clearly qualified for the job. Right? They didn't get it. A lawsuit is brought. Deposition of the hiring manager is taken. Did you rely upon anything other than the resume and the qualifications? Yes. What'd you rely upon? I looked at their Facebook page. And you looked at that Facebook page and making your decision. Isn't that right? My point is that that the Facebook evidence is not going to win a lose your case. The Facebook evidence is part of the mosaic that I believe that a lawyer can put together as part of the case. Is it going to be a slam dunk? No. Is it going to be helpful if something was looked at other than a qualification? I think absolutely. And I've tried a bunch of cases. I will say this, is that sometimes, and I was involved in a case like this, sometimes employers go and they get it wrong. So there was one case where the guy was fired for performance. One of the managers, for some reason, he was asked by, I'm probably going to get this off a little bit. The plaintiff, it was a race case or an age case, I can't remember, said, give me a recommendation on LinkedIn. And so the manager went to LinkedIn and didn't want to give a recommendation, but he didn't know what he was doing. And he gets on LinkedIn and he ultimately approves the guy, approves of him. However that stuff works on LinkedIn. I don't go there anymore. And so we had him testify. I made a mistake. I didn't really know what I was doing. And he was of my age. So it was sort of like he was not technically adept. And it came across as very believable that he didn't really understand what he was doing on LinkedIn. So when you go mucking around with social media, I think as employers, if you mess up, you just admit it. Kind of go back to Ashley's point. We had a lot of other reasons we didn't hire the person. Yeah, I looked, I was curious. Maybe in a perfect world, I would not do that. But if you've got a case, I think these factors, albeit at the margins, can make a small difference. And sometimes, in my experience, a small difference can make all the difference.
Right. Thank you for that. I know that you two mentioned Facebook and LinkedIn. From the employee standpoint, what are some things that they can do to kind of protect themselves from that? I think we generally know that an employer may or may not check our social media. Should we clean up our Facebook? Should we clean up our LinkedIn? Should we leave our LinkedIn open and only lock our Facebook? Like, what would you guys suggest as far as the employees and how to get ahead of this game?
Yeah, I think just similar to what I said before. I think LinkedIn is usually pretty safe territory. Although I have seen it, I mean, I've used it against people in litigation. There's a lot of ways you can do that. But generally, I mean, work history type stuff, I think is pretty fair game. Facebook, I mean, I probably sound like a Luddite here, but I just don't. I think the potential pitfalls with Facebook, Instagram, Twitter are just so much greater than the benefits. In most circumstances, I kind of just don't, I just tell people like, shut it down or change your name at the very least, set it to private and unfriend anyone who's associated with your employer. It's just what you stand to benefit from blasting all of your opinions to your coworkers is very, very little. Just stop it. That would be my advice as a plaintiff's attorney.
I would make 2 points on that. The first is, it comes from the wisdom of Chris Rock. No, really, he has a lot of really good stuff to say. And he was talking about dating. And he said that the woman you date isn't the woman you marry. No, the woman you date is the ambassador of the person you marry, right? It's the same thing with LinkedIn. There's a lot of falsehoods on LinkedIn. People make themselves seem more experienced than they are, smarter than they are, and that can be used to great effect by a defense lawyer. So this really is not accurate, is it? You put something that was inaccurate on LinkedIn. Why did you do that? Did you want to mislead people? That's fertile territory, right? Because on LinkedIn, there's a tendency, like all of us, to exaggerate. That is a weak spot of a plaintiff. The second thing is simply this, and I encourage when I was in practice, my brothers and sisters in the plaintiff's bar, but I encourage it now. You tell your client in a letter, don't delete anything. You send a letter to the plaintiff's lawyer. I look forward to working with you on this case. I am putting you on notice, not to instruct your client, not to destroy, tamper, alter anything on any social media, such as, but not limited to, Facebook, Twitter. I guess there are other things that I'm not familiar with. You get a newer associate, someone more savvy. And there will be consequences if you do. And I'm going to talk about the consequences. And so same thing with company, with the individual, is we don't have in Texas, there's no claim for spoliation, right? There's no independent tort for spoliation. However, if documents are destroyed, including something on Facebook, even if it's innocuous, and you get an admission to that, the court can give an adverse jury instruction, which essentially says, if this information had not been destroyed, you can presume, ladies and gentlemen of the jury, that it would have helped the defendant. And it's like ringing the dinner bell, right? For a defense lawyer. Come on down. What was on there? What did they not want us to see? I don't know how it plays out necessarily in every single matter, but it is a powerful tool, whether a defense lawyer uses it against a plaintiff's lawyer or vice versa. Don't do it, because here's the thing. It kind of goes back. Ask you something to think about it. I can't stress this enough. 98% of the stuff you put on Facebook may be embarrassing, but it's not legally relevant. Remember, it's the cover-up that's the problem, not the crime. And so people go and say, oh, I gotta delete all this stuff. Oh my God. Oh, this is awful. I can't do it. I've already brought this lawsuit, but I gotta destroy all this stuff. Just live with it. Just say, I made a mistake. Yeah, I was a little drunk that night, but I probably should have put the lampshade on my head, whatever it is. Just live with it and be honest with, tell your client that.
Well, to be clear, I'm not talking about when you're a plaintiff in litigation. What I was talking about is if you are about to go look for a new job, then that's a good time to try and clean things up and not even necessarily delete anything, just set it to private. So that you aren't just providing an open book for everyone to dig through. Right. In the litigation context, it is a little bit of a different story because you do have the spoliation issue. So what we usually have our clients do is, I want, on Facebook, for example, there's a way to download your complete history. Let's get it, put it in a black box, make sure everything is preserved, set it to private. Because here's the thing, we're going to preserve the status quo. I can fight with defense counsel about whether you get what's in the black box. Nothing's going to be deleted, but I'm not going to hand it over for free.
Well, how do I know what's in the black box? What do you expect defense counsel to do?
Forensics experts to be able to testify and say, this is what I did, here's what I clicked. Da, da, da. I mean, there are ways to do this cleanly and have the argument without just providing it for free and letting the other opposing counsel have a fishing expedition through your...
It's not a fishing expedition. I propound a discovery request to you. I say, you're suing us for whatever it is. I want, and you say, well, we downloaded it all, we have the black box. I want the postings for a year prior to her termination. And anything after her termination for 6 months. What's your objection to that?
Relevance.
I don't want us to get too far off into the weeds, guys. I do.
No. It is relevant. It is relevant.
Look, how that plays out most likely is we end up having an in-camera inspection, blah, 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 there's a big fight. But for the practical planning purposes, which I think was Tanika's question of like, what do you do if you're an employee and you want to kind of protect yourself? I think it depends on if we're talking about the litigation context or the job search context. In the job search context, I do think it's a smart idea to, like any other situation, put your best foot forward. Google yourself and see what comes up. And if it's unflattering, do what you can to clean that up, to put yourself in the best position to get the job that you want. And if you are not comfortable self-editing in that way, someone mentioned social media personalities.
Yeah.
They're like, this is part of my job, it's part of my persona to come out and say these things. I think that's fine. You just have to understand what the consequences are of that choice. So you can't have your cake and eat it too. If your deal is you want to be a social media personality and put it all out there, that's great, more power to you. But realize that there are going to be some consequences and some limitations as a result of that choice.
All right, and I also wanted to speak to the question that's in the chat. It says that even though an employer can terminate based on at-will employment, does providing a reason for termination dissuade the employee from seeking litigation? Or to Professor Maslanka's point, is it basically solely tied to the employer's conscience? So
it's funny, I was actually thinking the same thing when Professor Maslanka was mentioning that, because it is, I do kind of feel bad for employers sometimes because I think it is a bit of a double-edged sword for them, because I do get a lot of people calling me, and I think when they are not provided a reason, and they'll say, this is so fishy, it's so suspicious because they fired me, and the only reason they would give was, you know, Texas is at will employment, we don't have to have a reason. And they wouldn't tell me, and it was so upsetting, and that's kind of what drove them to the plaintiff's lawyer's door. I hear that a lot. Mm-hmm. So I do think, yeah, I mean, to Mike's point, I do think maybe there is some value in providing some reason to the employee. At the same time, the more reasons you provide, you know, the more kind of potential bones of contention the employee is going to have, or a plaintiff's lawyer is going to have. And a lot of employees have gotten really savvy, and they'll insist that it be in writing, or they'll record the termination meeting. And so the employer will say, the reason we're firing you is, you know, A, B, and C. And then when litigation comes up, you know, 6 months or a year later, we get, oh, well, the reason we fired them were C, D, and E. And the reasoning starts to evolve over time. And in the employment law world, I mean, that changing, that evolution of the explanation is evidence of pretext that we can use on the plaintiff's side. And so it is interesting. I think that employers can sometimes shoot themselves in the foot by providing too much of an explanation at the termination stage. At the same time, when they don't provide an explanation, that upsets people too. So I'm not really sure what the right answer is, but I have had people come to my door, you know, for both reasons. Right. Damned if you do, damned if you don't. I don't know, but Mike probably has more insight on what would be the best practice.
I don't want to get too far off on how to terminate. I want to try to stay on social media. I don't know if you had another question, Tanika. I mean, But I did want to talk about First Amendment rights.
Right, and that was where I was going. Look at that.
I'll let you ask the question. I don't want to presume.
Okay, so I did want to get to speech and talk about like some of the overarching questions. And of course, Professor, if you have any comments to make about that, absolutely make them. So the couple of the questions that I have include, do private sector employees have free speech rights to make inflammatory posts or comments? And then also on the other end of that, can we speak to public employees? And so some of these posts and comments, I mean, I know we've seen them where there have been teachers that have been fired for making political posts or comments or participating in certain groups and things like that. And then also there are people who work at private law firms like myself. Like, what are the chances are, and then can you be fired for that or not? Or then I know that there's also, I wanted to touch on, I think I saw it on social media where there have been recordings of people not being so nice to other people because of protected reasons, and they have on a work shirt. And so a lot of the response to that is people get together, see these comments, and they go to the employer and say, this person should be fired because does this company support this behavior, kind of things. And sometimes the companies, sometimes they are fired, and then sometimes the company will make a statement. Like, I just kind of want to know what you guys' take on those two issues are.
So here's the deal. If you're a private employer, or you work for a private company, you have no First Amendment rights, period. No but, no semicolon, none. By contrast, if you work for a public employer, if you are a firefighter, if you are a peace officer, police officer, if you are a school teacher, any action taken against you for what you say in public, a matter of public concern, right? As a general proposition, you cannot be retaliated against for exercising that right, because public entities are constrained in their actions by the First Amendment. And it's a very interesting case in Virginia in the Fourth Circuit involving the city of Petersburg, not St. Petersburg, but Petersburg. And a police officer posted on his Facebook page that the police department was, they were playing with the lives of the citizens. How? That they were having officers who were not experienced in street patrolling the streets. Another officer saw that, and he did not comment on it. But what did he do? On Facebook, what did he do? What we all do. What sometimes we even do to our own posts. We hit the like button, right? We hit the thumbs up button. And he was fired a few months later. He claimed it was for hitting the like button. And the trial court granted summary judgment to the police department. And the trial judge said, what is this? He was older. He was even older than I am. Right? I'm old, I'm 68. Said, this isn't protected. This is crazy. And the Fourth Circuit said, we live in a new age now. And going like this on Facebook is the functional equivalent of putting a sign in your yard supporting a political position. And it was remanded, it was reversed. There was some other evidence about this other police officer who did this, but that was considered protected expression under the First Amendment. And therefore, that officer could not be retaliated against for it. But as we were talking before we started, Ashley's right. It's got to be generally a matter of public concern. We disagree. I disagree a little bit. I think it's even broader than that. But that's the issue. That's the matter. And a lot of employees don't know that. But because we have more and more public employees, we're going to see more and more of these First Amendment claims.
Mm-hmm.
Yeah, I think Mike and I really pretty much agree on this particular question. The only thing I would add is I think a lot of employees, public employees that call us don't realize that that First Amendment right is not unlimited. So it needs to be on a matter of public concern, like Mike mentioned, but that world is getting broader and broader and broader, that definition of what is public concern. But it also, there's a sort of a balancing test that takes place after that. So that's sort of your threshold question. Is it a public matter of public concern? And was it made, you know, in your private capacity as opposed to your public employment capacity? And if the answer to, you know, it was done privately and it was on a matter of public concern, then there's still this balancing test that has to be done. And the employer can still fire you if the speech that you've engaged in is such that it kind of interferes with the ability to conduct their business. And so there was an example case, I think out of New York, when the George Floyd protests were going on in 2020, there was I think it was a court bailiff who had posted all over Facebook about like, here's where real justice takes place or something. And it had a picture of like Obama and Clinton, like hanging from a noose or something like really egregious. And because it was public, all sorts of, you know, jurors, litigants, parties had seen the post. And they all start flooding the court with calls and emails and complaints and saying, you know, to your point, Tanika, like, this person needs to be fired. This is outrageous. How can we expect equal justice under the law when we come into the court, when we know that the bailiff feels this way? And it turned into like this big hot mess. And he did end up getting fired because the court was saying, like, we cannot conduct our business efficiently when this person is here. And, you know, he of course raised the First Amendment issue of saying, like, I was speaking on a matter of public concern. It was political. I'm a public employee, blah, blah, blah. And they did the whole balancing test and actually ended up finding, I think, that the court was okay to go ahead and fire that person because on the balancing test, it was such that it was causing such a disruption in the courthouse that they went ahead to do it. But, you know, look, it's a fact issue. It's a huge gamble. I mean, there's not really a clear, bright line as to like which side of the fence your particular case is going to come down on. It's what do you get? Who do you get for juries? Who do you get for judges? I mean, it's a crapshoot. So it's a dangerous game to play.
I will say this. I'll make 2 quick points. First, I think the high school principal, the Black principal, I forget his name now, who was terminated last night, and I think it's Colleyville. I was on the radio a few weeks ago on this. I think he's going to bring a First Amendment claim. And I'm going to get in all the details of this case. You can read about it in the paper. It's in the news today. They had photos of himself and his wife, who happens to be of a different race, on the beach. And I think that's going to end up in litigation. The second thing I would make a point of is a lot of people don't understand that the National Labor Relations Act prohibits discrimination because of protected concerted activity. That is both for public employees and private employees. There's a recent case on the East Coast where employees of a restaurant went on Facebook and said that they were not being, their taxes were messed up and that the withholding was not done correctly and was not done correctly by management of the restaurant. And other employees chimed in on that. They got together to protest, to complain. And they did it, not at work, they did it on Facebook. The people who complained got fired. And that was a violation of the National Labor Relations Act. The National Labor Relations Board prosecutes those cases. But you have to bring them within 6 months as statute of limitation. But we're going to see social media merging with this claim for violation of protected concerted activity more and more because of social media. Those types of claims will accelerate.
I've had that claim.
Yeah. Right. So I just want to make sure I understand. So if I am a private employee, my First Amendment rights pretty much non-existent.
Zero, gone.
If I am okay. So as far as being a public employee, I have a little bit more protections. Does that sound?
Oh, you got a lot more protection.
A lot more.
The First Amendment protects you.
Okay.
And your public expression. Your expression over matters of public concern.
Right, right. And that leads me into, and also I want to make sure it was clear that liking, posting, resharing is pretty much the same as you making the post yourself.
Yeah.
Everybody. Yeah. Okay. Okay. And then also, go ahead.
I say just here's how I would, the quick and easy way to summarize it. The NLRA is actually doesn't cover public entities. It's just private sector. So
yeah, that's right.
It's pretty easy. If you're a public sector, you get the First Amendment. If you're private sector, you get the NLRA. And outside of those protections, you know, your speech is really not very protected. I
think that's a good way to summarize it. I did want to touch on 2 more points before we run out of time. I think one of you spoke about it a little bit, posting images. I wanted to know, I think I have the answer now that I've learned so much from you guys, but just so that the audience knows as well. So can an employee be fired for posting pictures of them in a swimsuit versus posting a Confederate flag or a Black Lives Matter flag? Like, what is your take on those two?
Private employer, yes.
Mm-hmm.
Public employer, maybe.
Yeah, I agree.
That's going to be the answer to pretty much every question.
Well, I don't know about that, but yeah, I mean, but I generally agree with that. Yeah.
Okay, and then as far as tips and tricks, well, not tricks, but tips for potential employees, is a bathing suit picture something that we should consider when we go through cleaning up the social media?
I guess it depends on who you're applying to work with, right?
What did you put it there for? Are you looking for a date? I mean, you know,
and also,
I mean,
is a Black Lives Matter flag?
I will assure you, let me just assure you, I don't have my Facebook on private settings, but I will assure you, you will never see, ever, Professor Mike Maslanka in a bathing suit on Facebook. I assure you of that. You may see other things, but that won't be one of them.
I think, Tanika, and to answer about the Black Lives Matter flag, I think this is like the #1 most surprising thing. I think to most employees that I speak to is that they seem very shocked and very surprised when I tell them, yes, you can be fired for anything you have on public media, whether it be, you know, your employer disagrees with your stance on Black Lives Matter or on the opposite end of the spectrum. I will say I've gotten a lot of calls in the past year from people who say, I was fired because I posted about supporting the January 6th insurrection or rally, depending on which side of the, you know, political spectrum you fall on. But a lot of people were fired as a result of that. And we got calls about it. And they're like, there's just no way. There's no way I could be fired for my political beliefs. I'm like, yeah, you absolutely can. And in some ways, I hope there is a bit of an employee awakening on this issue. Like, you do not have the rights that you think you do.
Yeah, it's interesting you mentioned Black Lives Matter. There's the First Circuit heard an argument the other day involving a case against Whole Foods. I won't get into all the details, where the employees got together and they sponsored the Black Lives Matter protests, right? And they were fired for it. And the First Circuit's considering various allegations stemming from that. So that's something to keep your eyes out for.
Okay. Yeah, no, thank you for that information. I'll be on the lookout for that. We did have another question that came in. And it says, cancel culture can also target businesses with bad reviews, including for employee actions. Any tips for dealing with a lot of negative reviews? I mean, that
I don't have a good answer for that. It's happened to my business. We had someone who didn't like how long we took to tell them whether or not we could take their case. And they went on Google and gave us like 1 star, you know, I mean, right. Our approach is to just ignore it and make sure that we have plenty of good, positive things to counteract it with.
I feel like the reviews are like the ways when they realize, okay, I can't really do anything legally about this, so I will come after.
I will say this though very quickly, because I think it's important. And there are cases on this. Lawyers, it is a violation of your ethical responsibilities to pretend to be someone on Facebook that you are not. Mm. You cannot go on Facebook and pretend to want to friend a plaintiff or a defendant and be something that you are not because you want to get the inside scoop on someone. That is a violation of your ethical duties. There's a case in Cleveland where an assistant district attorney did that. He was disciplined, he was suspended for 6 months and lost his job because he wanted to cotton up to the girlfriend of someone he was prosecuting for murder. Don't do it. Don't think about it.
All right, guys, well, we are going to wrap this up. Like Professor Maslenka mentioned, he has his own employer-employee interview to conduct very shortly after this. I just want to thank Tanika for leading this amazing panel. I think it was an awesome discussion. Thank you both, Ashley and Professor Maslenka. I think this was extremely educational for both of us as employees in a lot of instances and as lawyers. And so Sherry has shared the CLE number. I'll go ahead and read it out. It's going to be 174133087. And with that, thank you guys very much.
All right, thank you. Good to see you all. Good to meet you. Good to see you, Ashley.
You too, Mike. Bye, everyone.
Bye.